Good afternoon. I'm Jayashree from Institute of Sai and I take classes for Judicial Services. Yesterday we completed till section 63 of the Civil Procedure Code. We will be starting from 64 onwards today. Okay. So section 64, what does the heading say? Private alienation of property after attachment to be void. When there is a decree, that's what we were speaking about yesterday. When there is a decree for attachment and obligor sale, then the execution has to happen, right? That's what we were reading yesterday. So subsequent to the attachment, to the order decree of attachment, if any judgment debtor tries to sell or sells, see, there are chances, before the decree probably you would have settled with a purchaser saying that I'll sell this property to you, probably. Okay, so in that case, after the decree happens, once the decree is issued, granted, then the sale cannot happen, even though the sale has been agreed to before the issuance of decree. Clear? So once there is an execution petition, there cannot be any sale or any talks for sale of the property which is to be attached and obligor sold. Clear? So any such arrangements in order to sell or convey or transfer it in any way, any manner. That's why you can see here private alienation is given here. Alienation need not necessarily be sale. It can be transfer by any means. Clear? So by transfer by any means what? It can be either by way of gift or release deed, or there are so many things by which land can be alienated. Alienated means away from oneself. Am I right? So when there is a decree which has been issued and an execution petition has been filed, there cannot be any alienation except by the court authorities. Clear? So if at all the seller has got, the seller means the owner of the property, has got into any agreement or sale deed, or he has any plans in the sense it should be concrete. It is not, I'm just thinking of selling my property. It's not that type of planning, okay? Suppose he has gotten into a sale agreement, or he has executed, about to execute a sale deed or something like that, or a gift deed or a release deed or partition deed, anything of that matter, okay? So any type of alienation, if there is anything to be considered, then it shall be deemed to be void. Okay, so any purchaser who purchases under that shall be, the seller has no right to sell such property which has been attached under a decree. Okay, next we go to sale. Section 65, purchaser's title. See, purchaser's title, we know an ordinary seller and buyer, a vendor and a purchaser, when they are buying property and selling property, purchaser has got a good title, provided the vendor also has got a marketable title. Am I right? So same way, it is the same thing over here. Even though the land or the building is being sold by the court under a decree, in execution of a decree, it does not differentiate between a purchaser under a execution decree and a purchaser under a normal sale execution. Okay, so purchaser under a execution decree also has the same title, right, interest, absolute, okay, over the land or the building which is being sold under the decree. So in that case, there is absolutely no differentiation between the purchasers through a absolute sale deed in the normal course of transaction and a purchaser through a sale deed in such circumstances where there is a decree of the court. Okay, then next we go to section 67, power for state government to make rules as to sales of land in execution of decrees for payment of money. See, till now we have just read the general scenario, how the execution will happen if the judgment debtor, where a decree is against the judgment debtor, right? So here what the particular section 67 is very specific. It speaks about the powers of state government where the sales of land in execution of decree is for payment of money. Kindly underline that, payment of money. Okay, where there is a certain money which is involved which has to be repaid and has not been repaid, and the execution, attachment of the assets and the sale thereof is in execution of a decree. In that case, suppose then the state government shall fix a value. Otherwise, what it is, it will be the market value of the property, right? But when it comes to the sale of land for the execution of payment of money, then the state government has the right to make rules for such sale. Okay, because there's a special this thing. When on the date on which this code came into operation in any local area, any special rules as to sale of land in execution of decree were enforced therein, the state government may by notification in the official gazette declare such rules to be done to be in force, or may by a like notification modify the same. Suppose there are already rules in place in a particular local area. Earlier it was like that, am I right? So in a particular local area or something, there has already been rules with regard to such execution of decrees. Then the state government may either give a notification saying that we'll follow the same thing, or it may by notification amend or alter the rules which are already in place. Okay. Every rule made under this section shall be laid as soon as may be after it is made before the state legislature. That is what happens with all the rules. Am I right? So everything has to be laid before the state legislature and it has to be passed. All of us know that, right? Then next, section 68 to 72, which speaks about delegation to collector of power to execute decrees against immovable properties. See, these particular sections have been repealed. So the collector does not have any right to execute any decree unless otherwise specified by the state government from time to time. Okay, that rider is always there, unless specified by the state government from time to time. Okay, the next we go to the distribution of assets. How will the assets, once it is attached and the assets are sold, how will it be distributed? Okay, I'm not talking about the distribution of assets, even though it is written like that. Whatever are the proceeds from the sale. What is proceeds? Any money which is accumulated out of the sale of the immovable or movable property. That's known as proceeds. So proceeds of sale, how will it be distributed? Okay. Section 73 speaks about that. Proceeds of execution sale to be ratably distributed among decree holders. Okay. So it has to be ratably distributed among decree holders. Means what? Ratably means what? According to each one's claim. Okay. It has to be distributed among the decree holders. First, of course, provided as follows. Okay, you can see. Where assets are held by a court and more persons than one, where there are many creditors, right? Before the receipt of such assets made application to the court for execution of decrees, the judgment debtor, and have not obtained satisfaction thereof, the assets after deducting the cost of realization shall be ratably distributed among all such persons. That means what? The first expense out of the money which is got, the proceeds which is got out of the execution of, the sale of the property shall be towards the expenses incurred by the court for such execution of the decree. Okay. So whatever are the expenses which are there, that shall first be paid. Provided as follows. Where any property is sold subject to a mortgage or charge, the mortgagee or encumbrancer shall not be entitled to share in any surplus from such sale. Where it is a mortgage. Okay. The mortgagee, who is a mortgager and mortgagee, we already know. Mortgager is the person who keeps the property for mortgage, right? He mortgages the property. And mortgagee is the person to whom the property is mortgaged, right? So, what will be the share of the mortgagee? Only to that extent to which, even though, see, probably the mortgager would have kept an asset, say, for example, worth rupees 2 crores. Okay. But when the building is sold or the land is sold or whatever it is, when the asset is sold, though the court gets 2 crores, it is not necessary that it should not be given entirely to the mortgager. I'm sorry, mortgagee, even though the entire asset was in his custody, the property papers were with him. Okay. But even then, the entire 2 crores should not be given to the mortgagee. Why? Because the amount which was given to the mortgager in exchange for the asset would have been much less. So whatever mortgager owes to the mortgagee, only that shall be given. Not more, not less. Okay. B. Where any property liable to be sold in execution of a decree is subject to a mortgage or charge, the court may, with the consent of the mortgagee or encumbrancer, order that the property be sold free from the mortgage or charge, giving to the mortgagee or encumbrancer the same interest in the proceeds of sale as he had in the property sold. See, one instance is where the property is said to be a mortgaged property and it is sold by the court. Number 1. Okay, that's what we read in the beginning. Number 2 is what? The court has requested the mortgagee to free the asset from mortgage. Okay. In that case, what will happen? The court will give along with the premium amount which should be paid to the mortgager, the interest for all the months or years till it is sold, how much ever is the interest he would have accrued out of the asset, that amount shall also be included in the payment towards the mortgagee by the court out of the proceeds of the sale of the mortgaged property. Clear? Provided the mortgagee says, it's okay, I will free the asset from mortgage, you can start selling you can start the sale transactions, the procedure. Okay. Then C. Where any immovable property is sold in execution of a decree ordering its sale for the discharge of encumbrance, proceeds of the sale shall be applied. In what manner? Okay. Who will get the first preference? Who will get the second preference? Once the property is sold, who will get the preferences? First, who's in defraying the expenses of the sale? So first we'll go to the execution process itself, to the court expenses. The expenses that the court met while executing the decree. So the first preference, not preference, the first, how do you put it? The first lot will go to the court. Okay. Because the court has taken the expenses, it has taken up the expenses for selling the property. Secondly, in discharging the amount due under the decree. First one is what? Court. Second one is what? Under the decree. So whoever has filed the judgment debtor, the decree holder, will get the amount. Thirdly, in discharging the interest and principal money is due on subsequent encumbrances, if any. See, it is always, you would have read company law also, you would have read so many other laws, am I right? It is not necessary that one property, transfer of property itself says, act itself says, one property can be given to more than one mortgagee, right? So, where the decree holder, first right lies with the decree holder to get the money, then after him, whoever are the other creditors from whom the mortgager has taken amount, that is the judgment debtor has taken the amount, okay? All these people, the money will be distributed among all the other creditors. Fourthly, ratably among the holders of decrees for the payment of money against the judgment debtor, who have prior to the sale of the property applied to the court which passed the decree ordering such sale for execution and have not obtained satisfaction. Fourth, who gets it? All those people who have filed a case against the judgment debtor, okay, saying that he has to give me so much amount, he has to give me so much amount, he has to give me so much amount, okay. So they have filed separate cases or whatever it is, they have filed cases against the judgment debtor saying that this is what he owes to us, okay. So in fourthly, to whom will it go? To all the other creditors who have given money to the judgment debtor and who have filed a case against the judgment debtor. Okay. Number 2, where all or any of the assets liable to be ratably distributed under this section are paid to a person not entitled to receive the same. See, we have been saying to whom all it should be given, right? There are chances of mistakes occurring. So, if at all it is given to a person to whom it should not be given, he doesn't, the judgment debtor doesn't owe him money, or probably he has repaid him already. Okay? But still, since he is there in the list of creditors, probably by mistake it has happened. Then, in that case, what can happen? The person to whom the money is actually owed can file a case against the person to whom the amount is given for recovery thereof. Okay. Nothing in this section affects any right of the government. That means what? Where the government itself is the decree holder or any of the creditors, then the government has the right to take its revenue. Okay. Then section 74, resistance to execution. Say resistance to execution means what? Resistance means what? Any obstruction, any stoppage. Someone is trying to restrict, In that case, what happens? The judgment debtor is trying to restrict the authorities from taking possession of the building or land or whatever, and is also trying to obstruct the authorities from selling the property in executing the decree. Clear? Or probably, the next one it comes. Probably the purchaser, he has to be in possession, am I right, of the property. But the judgment debtor does not allow him to be in possession. Clear? So he doesn't give the possession of the land or building to the purchaser. So in this case, in such cases, what can happen? The authorities or the purchaser, okay, against whom the execution is being restricted, can file a case against the judgment debtor, and the judgment debtor will face civil prison term, okay, extending to 30 days, okay, but not beyond 30 days because it is a civil prison, right? So extending to 30 days, and also that the decree holder or any of the other creditors, whoever are the authorities, shall be put in possession of the property. Okay. So this is as far as attachment is concerned. Next we go to part 3. Incidental proceedings. Incidental proceedings means what? Any proceedings which happens in relation to the case which has been filed. Okay. In between we will need something. See, for example, practicing advocates will know we file the interlocutory applications, IA, right? So we file the IA in between. Okay. So sometimes the IA is something like, temporary injunction. You don't need anything except for arguments and evidences, and the judge gives an order on the temporary injunction, right? Sometimes what happens, there may be a need to appoint commissions, okay, to look at some of the documents or whatever it is, there are so many things for which commissions are appointed. So in that case, it becomes an incidental proceeding. There is a main case which is happening in the court. Meanwhile, there is a minor case. It is not a case, minor investigation or minor information gathering or whatever you want to put it, that is happening in relation to the case which has been filed. That is known as incidental proceedings. Clear? Now we go to commissions. Section 75. Power of court to issue commissions. Subject to such conditions and limitations as may be prescribed, the court may issue a commission. See, I already told you, application has to be filed by either party to the case. Not necessary that it should be only by the petitioner, plaintiff, or it should be by the defendant, respondent. Not necessary, right? Either party to the case can file a interlocutory application for appointment of commission. Okay. So, for what reasons, for what purposes can a commission be appointed? Number 1, to examine any person. Examine any person in the sense to take evidence of any person. See, I don't want to bring in other subjects here, but just like that, when we are looking at CRPC, okay, or even a civil case for that matter, absolutely no problem. Civil case, but one of the witnesses is in prison. Okay, Then a commission will be appointed to approach that person who is in prison and take his evidence. Clear? So even in civil cases, if one of the witnesses is in prison, we cannot say everybody is outside or everyone is inside the prison, right? So in that case, commission will be appointed to examine any person. Or maybe you can take, for example, any terminally ill person or someone who is bedridden who cannot walk up to the court, or any aged person, any what is it, Parda Nashin lady, right? So all this we already know. We have to put it into our mind in order to write down. Okay. So to examine any person, someone who cannot come to court, in that case, the commission will be appointed to go to that person and examine that person regarding the facts relating to the case which has been filed. Okay. Then number 2, to make a local investigation. Local investigation means whatever is the, when we say local, it doesn't mean area wise local. Okay. Here we are talking about within the case, whatever is necessary for the case. If any investigation has to be done, any information has to be gathered, then that shall be gathered by the commission. Any evidences has to be gathered and all that. Okay. Then C, to examine or adjust accounts. When it comes to the payment of money, whatever we were reading a little earlier, okay, the account statement of accounts will be maintained, books of accounts will be there. So in order to see that, commission can be appointed. Then to make a partition. Make a partition means what? See, adjusting accounts, you can even keep it as after the execution of decree, or while executing a decree, or before executing a decree. The court has to examine there are how many creditors to be paid, what all has to be done, how much will the accounts, how much amount will go to all these people, how much will be the balance, everything has to be taken into consideration. Clear? The next one, to make a partition. Where there is a partition, see, sometimes you have the interim decree and the final decree, am I right? So in between you will have a commission which is appointed to survey the property and say how many people are there in that particular family, okay, who are entitled to a share. Okay, so when this happens, a commission will be appointed in order to look at the metes and bounds of the land which has been, which is the subject matter of the case, and then to give it, then they have to see how many parties are there for the partition. Okay, and then they will see how much can be shared between among each party to the case. Okay, then E, to hold a scientific, technical, or expert investigation. We have read in this thing, Evidence Act, am I right? Expert, scientific or technical, these are all specialized in nature. So we cannot say everybody can do everything. It's not like that, am I right? So scientific, technical, or expert investigation, when it is needed, then only those experts will be called in for being members of the commission. Clear? So anyone who is related to scientific, technical, or expert, any expertise in any field, any other field other than scientific and technical, they shall be called upon to be members of the commission and then head the investigation. Then to conduct sale of property which is subject to speedy and natural decay and which is in the custody of the court pending the determination of the suit. See, commission can be appointed even for, see, for conduct of sale which is subject to speedy and natural decay. Okay, so something like fruits and vegetables, it decays very easily, right? So all these items which will decay very easily or which has an expiry date, medicines for that matter, right? Anything which will decay naturally. Okay, so for those things, for the sale of such movable properties, the commission may be appointed. Okay, there is no need for the final decree to happen and then the execution to take place. Okay, so in all these cases, interim sale can also happen. Then G, to perform any ministerial act. What do you mean by ministerial act? Anything which is in supplemental to whatever has been written here. Okay, these are all the main ones, not the main ones, the specific ones which has been mentioned, but apart from that, any other act is necessary which has to be taken, any ministerial act. implementation. Ministerial act means implementation. Okay. So in that case, commission can be appointed even for implementation of certain acts. Clear? Then section 76, commission to another court. Okay. See, it is not necessary that where the case was filed and the decree was passed by a particular court, only that particular court will have the right and the opportunity and the power to execute the decree. It is not necessary, because why? Sometimes what happens, the property may be situated in some other place. Say for example, the case is in Bangalore. The property is in Lucknow. Now, can a Bangalore court go all the way to Lucknow, or can the commission go all the way to Lucknow? No. So what will happen? There will be a delegation. Understand? So whatever is the um, procedure which has to be followed by the Bangalore court, that shall be given to another court, and a commission shall be formed to another court. Okay. In that case, see, in such a case, then the commission will have all the rights to, the procedure will be the same, the powers will be the same, the rights of the commission will be the same, everything will be the same. Okay, but only thing, instead of this state, it will be in some other state. That's all. Okay. Then section 77, letter of request. Okay. Letter of request, when will it be given? When a particular witness is not within the jurisdiction. He or she is not residing within the jurisdiction. Not only residing, it can be carrying on business or carrying on any trade. I think you must all be knowing all this. Okay. So in such cases where the person who is supposed to be giving a witness evidence, she is in another place other than where the court is situated, and the court has no jurisdiction over the other place. In that case, what happens? The court which is examining the case shall give a letter of request to the other court and request the other court to take evidence of that particular person. Okay. Then next we go to section section 78. Commissions issued by foreign courts. Subject to such conditions and limitations, the provisions as to execution and return of commissions for examination of witnesses shall apply to commissions issued by or at the instance of court situated in any part of India to which the provisions of the code does not exist, or by the authority of the central government outside India, or courts of any state or country outside India. So commissions can be appointed even for foreign courts or any court within India, but where the India central government does not have its jurisdiction, where the courts don't have its jurisdiction. See, for example, our Code of Civil Procedure, if you look at the short title and extent, you will say that it is not applicable in, of course, now Jammu Kashmir is not there, but you have it in Manipur, Nagaland and other tribal areas. Am I right? So in that case, commission can be appointed for execution of decree as if it is in a foreign country. Understand? So it can be a foreign country, or it will be someplace within India, but not within the jurisdiction of this particular code of civil procedure. Then also a commission can be appointed. Okay. We will stop with this today. We'll continue tomorrow. Thank you.